Okay, hello class. We got through some of the slides on Wednesday from the PowerPoint from chapter 8, but I wanted to just finish the lecture on these slides on this chapter, and we left off on capital punishment. In the book, they discuss in Furman versus Georgia. It's a 1972 case where they talk about the death penalty laws in all states were struck down as being arbitrary and capricious by the U.S. Supreme Court. The court found that the imposition of the death sentence varied so greatly from case to case and that it was just simply being administered in an unfair way. And so the Supreme Court said if the states are going to impose capital punishment, they have to find a better way to do so. So after that, many states did change their laws. And so now the state statutes have to identify the crimes that are punishable by death. It can't be arbitrary where one person is before them and they decide, oh, we're going to go after you on the capital. We're going to apply capital punishment to you. But then the next person, they won't apply it even though it's the same crime. So the states now have to identify the crimes punishable by the death penalty, whether it's going to be tried by the trial judge or the jury, who decides what method would be inflicted, and the entire appellate process. So, for example, in California, the jury decides whether or not the person's going to receive death, and then it's separate from the guilt phase. So they break up the trial. But I'm going to talk about California in just a minute because there have been a lot of changes. But the state statute requires juries and judges considering the death penalty to make findings of both aggravating and mitigating circumstances. So, for example, aggravating circumstances if the person tortured the victim, the extent of the suffering of the victim, that would be aggravating. A mitigating circumstance may be that the person, the defendant, was a victim of sexual abuse all of his life, or he has some mental issues. So that's an example of mitigating circumstances. All right, Texas, Missouri, and Georgia account for 86% of the executions in the United States. Nebraska and Connecticut have declared the death penalty to be unconstitutional. California's death penalty was recently declared unconstitutional on July 16, 2014, because it was found to be arbitrary and plagued with delay. There are currently 744 people on death row in California, and so the federal district court, the federal district judge that found our death penalty to be unconstitutional said that apparently there is a huge problem for California to have so many people just waiting on death row all this time. That process alone is unconstitutional. And so California has not executed anyone since 2006. So it's been over 12 years. So we currently do not have a death penalty law in place because it's been determined to be unconstitutional. We talked about the gas chamber in class. Now, if death penalty is used, it's by lethal injection. The gas chamber is determined to be cruel and unusual. So let's go to the next slide. I'm just going to breeze through here. Fines cannot be excessive. You look at the type of crime, the criminal conduct, the maximum sentence for the fine, and the nature of the harm caused. All of that is determined and is looked at in determining whether or not the fine is excessive. So I'm going to upload this PowerPoint so you can read those slides further. I'm going to get to three strikes law. It's interesting that the federal government actually has a similar three strikes law. It's called the Armed Career Criminal Act. And this is where it's the federal government's law that provides for increased punishment of 15 years for a person convicted of being a felon in possession of a firearm statute. And that person had 3 previous convictions for drug offenses or violent crimes. I think this is on, if you look at page 225 and 226, it talks about how the federal government has determined that that third offense has to be a violent crime. The trial judge can't go looking at the facts to determine if some of the actions of the defendant were violent. It actually has to be a violent crime, the third offense, to trigger this 15-year enhancement. So the first requirement is that they were convicted of being a felon in possession of a firearm statute, and that person had 3 previous convictions for either drug offenses or a violent crime. If they did not, and that's the case that they talk about on page 226, the DeCamps case, where the trial judge gave him an extra 15 years because he had a burglary conviction on his record from California, but the court found that because California has a variety of crimes that cover a burglary, it was improper for the judge to go and look to see what the facts were, because by itself, a burglary crime in California is not considered a violent crime. So they had to reverse his sentence. So instead of the guy getting, I believe it was 35 years, he actually got 10 years. All right, so many states now, including California, have what is called the 3 strikes law. And so that just means that if you have 2 felony convictions, and it has to be serious felonies, and there's a list in California in the penal code, you can look that up. But if you have 2 serious felonies, and then you get arrested on a third case, and even if it's not a serious or violent felony, you could face 25 years to life. So for example, if someone had 2 serious felonies and they decided to go into Walmart to do a beer run, and so because of their record, the DA doesn't charge it as a misdemeanor, they charge it as a felony, they charge it as a commercial burglary. That person could face 25 years to life for doing that beer run. And the California law was, California 3 strikes law was challenged in a case called Lockyer versus Andrade. It's, I gave you the site if you want to look it up. So that person challenged California's law, saying that it amounts to sentencing someone to 25 years to life for any third conviction, no matter how serious or violent, is a violation of cruel and unusual punishment, a violation of the 8th Amendment, and therefore unconstitutional. However, the U.S. Supreme Court found that it was not a violation of the 8th Amendment, and the U.S. Supreme Court upheld that conviction and the sentence of Andrade. You can look at more about that on pages 227 and 228. However, a really big thing happened in 2012. And so we have a new California 3 strikes law. So in 2012, the voters approved what was known as Prop 36, where they approved a change in the 3 strikes law. So now, instead of any felony conviction, no matter how minor, amounting to a person facing 25 years to life, the voters approved a change to that law that now requires that in order to trigger that 25 years to life requirement, the third conviction has to be serious or violent felony. It can no longer be for any type of felony. This change resulted in thousands of individuals. First of all, I'm sure they were screaming for joy, but it resulted in thousands of individuals having a right to be resentenced if a judge determined that the third strike was in fact not serious or violent, and that the resentence would not pose an unreasonable risk to public safety. So in order to get this law approved, they had to add this last part of the language to make sure that it was that a judge still determined, yes, it's appropriate to resentence this individual, and because he or she, their third offense that resulted in their 25-year life sentence was not a result of a serious or violent felony, and for the judge to make an additional evaluation to make sure that the resentence of that person would not pose an unreasonable risk to public safety. So in other words, letting that person out of custody sooner would not pose a risk of safety to the public. So that was how they were able to get that law on as a proposition to have it go to the voters. So that concludes the Chapter 8. I will download the PowerPoint and give you further instructions on when the quiz will be available. It'll be a short quiz. It's only going to be 10 questions. And then next week we will talk about the next chapter briefly, and then we will finish watching the case about the 12-year-old lifer. I know a lot of you wanted to finish watching that. I want to finish watching it to see what happens. So I hope you enjoy the rest of your weekend, and I will see you next week. Thank you.